Moving on to Lawrence v. Texas. Justice Kennedy writes the majority opinion in this case, which is 6-3 with regards to the statute and 5-4 in regards to extension of privacy. But Justice Kennedy, in sort of a unique way of writing an opinion, before he even gets to the facts, in the very first paragraph of his opinion in this case, sets out the confines of what he's going to talk about. And he says that liberty protects the person from unwanted government intrusions into a dwelling or other private places. In our tradition, the state is not omnipresent in the home, and there are other spheres of our lives and existence outside of the home where the state should not be a dominant presence. Freedom extends beyond spatial bounds. Liberty presumes an autonomy of self that includes freedom of thought, belief, expression, and certain intimate conduct. The instant case involves liberty of both persons in its spatial and more transcendent dimensions. We should know where this case is going. A little bit about Justice Kennedy in this area. Every case since 1996 that has dealt with gay rights in some aspect that the Supreme Court has heard, Justice Kennedy has written the majority opinion. He very much had attempted to carve out this area as his defining area while on the court. They're very well written, very easily read opinions. They're not necessarily good law. And we'll see that more when we get to the next two cases that Kennedy writes. And so in Lawrence v. Texas, Texas law prohibited sodomy, defining sodomy as anal or oral sex between persons of the same sex. And such acts were obviously not prohibited between persons of opposite sex. And so in a case that is very similar to Bowers v. Hardwick, police entered the defendant's home on a reported weapons disturbance and observed the men having anal sex and arrested them. As a side note, the neighbor who filed the weapons disturbance complaint was later convicted of filing a false police report. So what the neighbor wanted, which was to get these two individuals arrested, happened. And also the neighbor himself got cited for filing a false police report. So typical Texas behavior. Both men were adults at the time of the alleged offense, and their conduct was entirely private and consensual. They pled nolo contendere, were convicted of violating Texas law, a misdemeanor, fined $200, and assessed $141 in court costs. The convictions in this case were upheld in the Texas court system based on the controlling authority of Bowers v. Hardwick. That is, the state Supreme Court dealt with the lower Texas courts dealt with the issue, the state Supreme Court dealt with the issue, and because of the precedent in Bowers v. Hardwick, they simply cited Bowers v. Hardwick and said that it was controlling. So Lawrence, in this case, appeals his case to the U.S. Supreme Court. And there are three issues that are before the U.S. Supreme Court in this case. First, does the law violate vital interests in liberty and privacy protected by the due process of the 14th Amendment? Does the law violate the Equal Protection Clause of the 14th Amendment? And should Bowers v. Hardwick be overturned? The answer to all of those questions is yes. The decision goes through a long history of the Supreme Court's legacy on privacy decisions, beginning with Griswold. The Supreme Court even revisits the history of some of those sodomy statutes, and it argues that laws prohibiting sodomy do not seem to have been enforced against consenting adults acting in private. A substantial number of sodomy prosecutions and convictions for which there are surviving records were for predatory acts against those that could not or did not consent, as in the case of a minor or a victim of assault. So far from possessing ancient roots, and Kennedy is citing back to Bowers here, citing back to the opinion of Bowers. He says, far from possessing ancient roots, American laws targeting same-sex couples did not develop until the last third of the 20th century. They go on to discuss that how not until the 1970s did states actually begin to criminalize only homosexual conduct, and only 9 states ever did so. Of these, only 4 states continued to ban homosexual sodomy. Those were Texas, Kansas, Missouri, and Oklahoma. And of the 25 states that were cited back in the Bowers v. Hardwick decision that banned sodomy against both couples, only 13 now ban sodomy, which included those 4 states previously referenced. And so we'd gone from 25 to 13, and of those 13, only 4 states targeted specifically homosexual conduct. The opinion goes on to discuss the liberalization of laws regarding homosexual activity and behavior in Europe. And when opinions do this, they do so for the reason that a lot of our historic case law evolves from Europe. And so by comparing their evolution to our evolution, it's provided as a means of reasoning by parallel paths. But countries in Europe had been changing their laws regarding ban homosexual conduct, and this recent trend allowed the Supreme Court to cite other courts and other decisions from other countries. Kennedy writes that, in summary, the historical grounds relied upon in Bowers are not, without doubt, and at the very least, are overstated. Bowers acknowledged powerful voices condemning homosexual conduct as immoral. These beliefs are not trivial, as they are based on religious, ethical, and moral grounds by which many individuals, indeed perhaps a majority, live their lives. But the issue is whether the majority may use the power of the state to enforce these views on the whole society through operation of criminal law. Our obligation is to bind the liberty of all, not to mandate our own moral code. And in that case, in that line, Kennedy is citing back to Casey, Planned Parenthood v. Casey, when he says our obligation is to define the liberty of all, not to mandate our own moral code. And so, moving forward, the court says that this absolutely it runs afoul of our notions of individual level privacy, but furthermore, it's problematic with regard to the Equal Protection Clause. And part of the reason that Kennedy argues this is because of the stigma that being arrested for this law creates. He writes that the stigma this criminal statute imposes, moreover, is not at all trivial, because individuals charged with violation of the statute had to register as a known sex offender. He writes fairly persuasively that Bowers was not correct when it was decided, and it is not correct today. It ought not to remain binding precedent. Bowers should be, and now is, overruled. So this is an extension of a due process right, and it's using the 14th Amendment to do so. Kennedy makes it pretty clear here. Petitioners are entitled to respect for their private lives. The state cannot demean that existence or control their destiny by making their private sexual conduct a crime. Their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without intervention of the government. So not only is there a privacy right here, it's a substantive due process right via the 14th Amendment, which means that this activity is read into the Constitution, and all laws that are in violation of that should be struck down. So by casting a substantive due process right to privacy for homosexual behavior, the net is cast exceedingly broad. Now, the court could have simply decided the equal protection argument and not extended a substantive due process right, but they choose to here because Kennedy feels that that right flows from previous case law. Justice O'Connor concurs in this decision. She was part of the Bowers majority and argues that the case should not be overruled. She argues that the Texas law is unconstitutional because of the Equal Protection Clause based on a simple rational basis test. That Texas clearly treats the same conduct differently solely on the basis of participants. And that is a violation of equal protection. So for O'Connor, she feels that the law is a violation of the Equal Protection Clause. That's the sixth vote with regards to that question. But she does not join the court's majority in finding a substantive due process, privacy-based right to engage in homosexual activity. So her argument with regards to the equal protection stent is that a law that brands one class of persons as criminals solely based on their membership in that class runs afoul of the Equal Protection Clause under absolutely any standard of review a court could use. The dissents go a very different way. Justice Scalia dissents, and Justice Rehnquist and Justice Thomas join. And Justice Scalia writes that the majority overrules Bowers, but does so under a standard of review that is different from what was decided in Casey. They argue that homosexual sodomy is not a fundamental right, but the only way a substantive due process right is protected as a liberty interest under the substantive due process is if it is a fundamental right. He makes it very clear that the Texas law is a restraint on liberty. But there are many other examples. Laws prohibiting prostitution, the use of heroin, the working of over 60 hours a week. But since there is no fundamental right involved there, then the state can take away someone's liberty as long as there exists due process of law, which there was in this case because the state properly passed this law. And he answers back that Bowers was correct in 1986, and it is still correct in 2003. The Texas law seeks to outlaw immoral behavior, same as outlawing fornication, bigamy, adultery, adult incest, bestiality, and obscenity. And so there's no fundamental right that should be read into the Constitution here. On the discussion of equal protection, Scalia writes that the Texas law does not even violate equal protection because it treats men and women equally. And he goes on to argue, perhaps somewhat presently, is that this is the exact same situation, which is still legal after this case, in which the state denies homosexuals the right to marry, that it's treating men and women equally. He states that today's opinion is the product of a court, which is the product of a law profession culture that has largely signed on to the so-called homosexual agenda. It is clear from this that the court has taken sides in the culture war, departing from its role of assuring as neutral observer that the democratic rules of engagement are observed. Let me be clear that I have nothing against homosexuals or any other group promoting their agenda through normal democratic means. Social perceptions of sexual and other morality change over time, and every group has the right to persuade its fellow citizens that its views of such matters are the best. Justice Scalia continues because he implies that since this law has fallen, the next law that will fall will be prohibitions upon gay marriage. And he writes this in 2003, and that that sort of Scalia could see into the future, because that is the next issue that we will deal with in this class.